Hello and welcome to the Race and Rights Podcast. This is Sahar Aziz, distinguished professor at Rutgers University Law School and author of the book, The Racial Muslim, When Racism Quashes Religious Freedom. I also serve as the director of the Center for Security, Race and Rights, which engages in research, education, and advocacy on law and policy that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. You can learn more about CSRR's work by visiting our website at csrr.rutgers.edu and also subscribing to our YouTube channel. Today's episode is entitled Race and Empire, Legal Theory Within, Through, and Across National Borders, featuring Yale law professor Asli Bali. Professor Bali examines how racialized logic and imperial prerogatives in international governance regimes operate at the periphery of the global north. Dr. Bali highlights the often overlooked consequences of post-colonial management by Western actors and the lack of engagement with regionally informed perspectives on empire and race. Let's hear what our guest has to say about this important topic.
I want to acknowledge how important it is to have a center like this one based at a U.S. law school and focused on the human and civil rights of Muslim, Arab, and South Asian diasporas in the United States through both a transnational and an interdisciplinary approach. That framing, the emphasis on the transnational and the interdisciplinary, offers a truly wonderful platform for generative thinking that pushes conventional boundaries of law schools and the kinds of thinking that separates civil rights from human rights, the thinking that separates immigrant communities from their diasporic ties, that separates the fate of Muslim communities within the U.S. from the broader global context in which their trajectories need to be understood. So this platform is one that's perfect in some respects for my own intellectual interest, which is precisely in those transnational ties that you emphasize in the framing of your center. My talk today is based on a paper I co-wrote with a friend and colleague, Tendaya Achiume, who, like me, is professor of law here at UCLA, but is also currently serving as the United Nations Special Rapporteur on Racism and Xenophobic Discrimination. Tendaya and I set out to put together a project that precisely makes visible the interwoven connections and threads that tie our current predicaments domestically and internationally and bring critical thinking about race in the U.S. context into conversation with scholars that focus on the legacies of colonialism and contemporary imperial formations in the international context. More specifically, we were very interested in bringing two scholarly traditions and approaches at the domestic and international level together and into conversation to generate analyses that place race at the heart of work on national and international security logics and surface the ongoing relationships between race and empire. So again, a framing of a center that focuses on race and national security could not be more apt for a presentation like this one and couldn't reflect better what I think is a vital intellectual agenda that we should all be pursuing for those of us that are interested in the ways in which Muslim communities are racialized in the United States. We need to understand the relationship of that project to the broader governance arrangements that affect the Middle East as a whole. So with that, let me just say a little bit about that intellectual conversation we hope to start, and then turn to the specific case of Libya, which is the example that we take up in the paper to demonstrate the interwoven and sort of layered relationships between race and empire in governance in the Middle East. A little bit of background on critical race studies and third world approaches to international law. Most in the audience, I'm sure, will be very familiar with critical race studies. So this is an area of law that has largely been focused on domestic analysis of race and anti-discrimination in the United States context that has built up an enormous theoretical and incredibly impressive theoretical infrastructure for thinking about race as a social construction and examining the role of law in producing forms of racial subordination. It's a project that is also invested in thinking about the emancipatory potential of law, of rights in particular, under law as a means of addressing subordination and beginning to dismantle the structures that and the edifice that supports structural discrimination. So on the CRS side, the domestic project, if it's focused on race and rights, on the international side, another approach that may be less familiar and is known by its acronym TWAIL, Third World Approaches to International Law, is focused on the analogs at the international level, which are sovereignty and intervention. So TWAIL is an anti-imperial and anti-racist project at the international level that provides a critique of international law that is very much analogous to the domestic critique of the role of law in the production of racial subordination. But here it is looking at the ways in which international law and race have been mutually constitutive with empire, and focusing specifically on ongoing colonial logics that are embedded in contemporary international law. So I just want to give one small example to give a sense of what kinds of doctrines we're talking about. As an example, derogation rules in international humanitarian law and human rights law, so rules that allow the temporary suspension for emergency purposes of particular human rights protections, derive themselves from an introduction by the British in the European Convention of Human Rights, one of the first multilateral human rights treaties of the post-war order. The British introduced this as a basis to suspend the application of human rights protections it was signing up for, insofar as they would apply in the country's overseas territories. So the TWAIL scholar John Reynolds has laid out beautifully a history in a recent monograph on emergency laws and their colonial origins, exactly how and why the British introduced this doctrine of suspending rights protections under emergency conditions in order to effectively suspend the application of human rights protections from Kenya to India in its overseas territories at that time. So this was a fundamentally colonial logic that said human rights protections will be reserved for those white imperial citizens located in the metropolitan center, and we will have a separate doctrine to suspend their application in overseas territories. But this logic continues to the present day as a derogations doctrine that is invoked routinely in international human rights law, again, oftentimes to justify the suspension of rights under conditions of emergencies in ways that target racialized communities, often immigrant communities, again in the metropolitan center. So TWAIL, Third World Approaches to International Law, sheds light on how historical antecedents of modern international law more broadly embodied and advanced colonial logics of racialized exploitation, expropriation, and extermination in ways that have contemporary legacies in the current international legal order. And understanding these ongoing imperial relations, TWAIL scholars conceive of social, political, and economic interconnection among sovereign nations as themselves structured on fundamentally unequal terms that benefit powerful nations and structurally disadvantage and exploit subordinated nations. So these relationships of asymmetric situation with respect to the operation of contemporary international law doctrine is one way that the logic of empire continues even in the absence of colonies. TWAIL, like CRS, also wants to retrieve the emancipatory potential of international law, to think of international law as a set of standards against which great power conduct can be judged and altered, and thinking about ways doctrines can be repurposed to hold interveners and those who would suspend the rights of persons in the global South accountable for their actions and conduct. So we were very invested in thinking about how to bring critical race scholars in the domestic US law context into conversation with scholars of TWAIL in order to really center race as an analytic lens through which to understand the operation of empire at the international level. So that is the intellectual background of this project. And then in setting up what the sort of theoretical work might look like, we decided to make concrete the benefits, the payoff that you might get from this analytic approach by engaging in a systematic analysis of the Libyan case. And that really is the bulk of the paper that was circulated to some of you and what I would like to say, discuss and engage for the rest of this presentation. So the Libyan case we examine is the case from the 2011 international intervention on purportedly humanitarian grounds in Libya through to the current day operation of both counterterrorism and migration governance arrangements on Libyan territory. And the question we ask is, how might centering race as an analytic lens and empire as a structural account transform the conventional understandings in international law of what happened in the Libyan case? As a matter of just the big picture here, we argue that geopolitical hierarchy basically renders third world sovereignty penetrable and contingent to international and what we view as imperial interventions. We examine how international law in the Libyan case facilitated military intervention against Libya, resulting in the destruction of that state's infrastructure, and then how the unmaking of the Libyan state, in turn, enabled logics of counterterrorism-based policing and coercive population management regimes to be applied in the country. We noticed that the privileging of Libya's identity as an Arab state at the expense of its identity as an African nation and its ties to the African Union, were cynically deployed at the international level to relegate the African Union to a secondary status and to promote the League of Arab States as the relevant international interlocutor at the regional level with the United Nations for the purposes of enabling intervention. And later, the ways in which the emphasis on Libya's Arab identity further enabled the framing of the country as an incubator of terrorist threats to be managed. And finally, Arab Libya being marked racially as a transit site where the EU might partner with various actors to block Black African migrants, allegedly foreign to Libya, from transiting through Libyan territory and across the Mediterranean to Europe. So establishing what my co-author Tendaya Chiume has described as Europe's racial border on Libyan soil. This analysis that I just gave in a very big picture form, and then I'm going to break down in a moment, contrasts with mainstream international legal accounts of the intervention in Libya and its aftermath that cast great powers as humanitarian responders to a crisis not of their making. We regard the international system and hegemonic actors instead as critical to creating the conditions of possibility for the implosion of Libya. And we view the international system as sustaining internal dysfunction in Libya while seeking to contain the effects of that dysfunction within Libya's borders. So the project of stabilizing Libya is about allowing and sustaining the kind of destabilization that persists on Libyan soil while preventing it from exceeding Libya's borders, specifically to Europe. Okay, so let's turn then to the three forms of intervention: humanitarian intervention, counterterrorism, and migration, as the three areas where we unpack these logics of international law and their operation in Libya. And I'm going to focus most heavily on the humanitarian intervention and counterterrorism context, but I'm happy to discuss the migration governance regime in Q&A as well. With respect to humanitarian intervention, as many of you know, Libya was the site of one of many Arab uprisings in 2011, beginning in Tunisia in December 2010 and continuing through Egypt, Yemen, Syria, Bahrain, many other countries in the region that experienced popular uprising of people, protesters, rising up against authoritarian regimes and demanding rights, social justice, and dignity. And in all of these cases, the response to these protesters was initially violent repression. This was least true in some respects in Tunisia, where the Tunisian military intervened itself to mediate a solution and facilitate the exit of the long-term authoritarian leader from the country, refusing to take up arms against their population. Elsewhere, however, from Egypt and Yemen to Bahrain and Syria, we saw quite repressive responses from the regimes of the region to protesters. And in many cases, the protests were put down, with Egypt being an exception that I'll return to. In Libya, when protests emerged, which was after these events first began in Tunisia, Egypt, and even Yemen, so it was mid-February by the time that protests began in Libya, you had a very different international response than was witnessed in the other Arab uprisings. With the other Arab uprisings, each of the countries involved, it had a major external patron, whether it was the United States in the Egyptian context or Russia in the Syrian context, for example. There were significant, powerful external actors invested in the continuity of those regimes and in managing whatever threat might exist to the longevity of the regime, backing the authoritarian powers against the protesters on the ground. In Egypt, this resulted, as many of you know, in ultimately a form of managed transition in which the armed forces of Egypt, continuing to be backed by the United States and other actors, initiated a transition which brought a democratically elected government briefly, but was overturned by a military coup, again with support from the West. In the Libyan context, however, there was an opportunity that emerged. Libya distinguished itself from other countries in the Arab uprisings, not because of the brutality of its crackdown against protesters. Actually, there was no large-scale killing of civilians in Libya prior to the intervention that was undertaken there. Rather, what distinguished Libya from the other Arab uprising countries was the absence of this kind of an external patron, as well as the alienation of the Libyan regime itself, run by long-term authoritarian dictator Muammar Gaddafi, his alienation from the regional arrangement for the Arab world, namely the League of Arab States. So Gaddafi had neither a Western external backer nor the support of other Arab authoritarians in the region. Instead, Gaddafi had invested for a very long time in relationships with the African Union, regarded Libya's place in Africa as central to its regional identity. So from here, let's turn back to the international context. Libya represents the first deployment of a doctrine called the responsibility to protect, which is a doctrine that was developed in the early 2000s as an argument for international responsibility to protect the civilian welfare of a population in circumstances where its regime might be threatening the security and the welfare of the civilian population. To date, until 2011, this doctrine, R2P, had been invoked in order to facilitate humanitarian assistance of a variety of kinds, and at the most extreme end, peacekeeping forces deployed that did not have authorization to use offensive force, so coercive force against the state, but rather were meant to protect civilians in a defensive posture. Libya represents a break from this. So Libya is the first deployment of this doctrine, the Responsibly Protect, to authorize coercive action under UN Security Council authority. Libya faced this action not because it threatened its neighbors, which is the traditional basis for a Security Council authorization for the use of force, but rather on the grounds that its civilian population required protection. In other words, the nation's sovereignty was set aside in the name of humanitarianism against the purported barbarism of Gaddafi, and much was made of the kinds of threats that Gaddafi might represent to his population. In many ways, the framing of Libya reflects the highly contingent nature of third world sovereignty. External judgments about the character of Libya's government was sufficient to ground military aerial assault on the country intervention. The first UN Security Council resolution in the context of Libya was brought into effect 10 days after the protests began. So within 10 days of the protests, with dozens of protesters having been killed, but that's the full extent of the violence that had occurred in those first 10 days, Libya was subjected to sanctions, an asset freeze of all of the sovereign wealth of the country, and a referral of the regime to the International Criminal Court for investigation for possible crimes against humanity. This against a backdrop of far greater civilian death, even in the relatively peaceful context of the Egyptian transition, and certainly what was going to unfold over the coming months in the remainder of the Arab world, in Yemen, and most particularly in Syria. By contrast, you had significant UN Security Council action here before large-scale casualties had occurred amongst protesters in the Libyan context. As I've mentioned, something that distinguished Libya was its absence of external power protectors, patrons, specifically on the Security Council, and also the absence of support on the League of Arab States. So Libya represented an opportunity for Western powers to establish that they were on the right side of history as uprisings swept across the region, and it gave them an opportunity to intervene against an internationally unpopular regime without costs to the regional security arrangement that they maintained with the other authoritarians of the region. Moreover, they were able to purport that they had the regional support of Libya's principal regional interlocutor, here styled as the League of Arab States. Now, it's important to note that Libya itself rejected the notion that the League of Arab States represented its proper regional interlocutor. Instead, as I've mentioned, it favored its ties to the African Union. And the African Union at this time was engaging in aggressive efforts to try to come to a mediated solution, that is a solution resembling the outcome in Tunisia, in which a negotiation between protesters and the government could witness the departure of Gaddafi and his family while maintaining some, modicum of stability and interim governance arrangements in Libya. These efforts were rendered secondary. They were sidelined in the international context because two arguments. The first, that the AU was not the proper regional interlocutor, that Libya was best understood as an Arab state, was framed at the Security Council, privileging the League of Arab States as the interlocutor, backburnering and sidelining the AU's attempts at a mediated solution. And then arguments about civilian protection were deployed in highly racialized ways. Gaddafi was depicted as deploying Black militias against unarmed protesters in the Libyan context. And there's been a lot of work done on exactly the empirical basis for these allegations. It turns out that there was a very limited use of any sort of mercenaries on the part of the Gaddafi regime, and that the individuals that were being described as Black mercenaries in the UN Security Council and in other international contexts were indeed themselves Libyan citizens who had long been residents on Libyan territory, but the framing of Libya as Arab and not Black African facilitated this depiction of Gaddafi as savagely using mercenaries against protesters. So under these circumstances, what you ended up with was an intervention on the part of NATO, an aerial intervention authorized by the UN Security Council 3 weeks after that first Security Council resolution imposing sanctions. This intervention resolution allowed a nearly untrammeled use of military force in order to protect civilians, but the civilians that were going to be protected were very particular. The argument about civilian support was deployed in ways that underscored the imperial logic of the intervention under cover of humanitarianism. Not all civilians were equally entitled to the protection. Those supportive of the Gaddafi regime, that is, civilians that were located in the western parts of the country, faced an enormously high death toll at the hands of rebel attacks supported by NATO airstrikes. And nor did the humanitarian logic of assistance to the civilian population extend to rebuilding the destroyed infrastructure of the country. Rather, once the intervention ended and the Gaddafi regime had been overthrown, the country lay in tatters, its infrastructure destroyed by aerial bombardment. An asset freeze was maintained that prevented interim governing authorities, so Libyans that were seeking to establish a new government in Libya for interim purposes following the end of the Gaddafi regime, were prevented from accessing the sovereign funds of the Libyan state, which were held in Western Western banks under UN sanctions, and the terms that were provided for the lifting of the freeze on those assets were to be defined by the Security Council. So the Security Council was to be satisfied with the character of the governance arrangements put in place on Libyan territory before Libyans themselves could access the wealth of the nation. So this, in many respects, is an example of what we might describe as imperial privilege in a world without colonies. The UN Security Council serves as the arbiter of when Libyan authorities may access their own funds in order to rebuild a country destroyed under UN Security Council authorization for allegedly humanitarian purposes. Meanwhile, the same funds that the Libyan authorities cannot access are held in banks in the global north, generating continued use for investment purposes by the international financial system located in the very countries that now serve as the arbiters of when Libya's sovereignty may be restored. Moreover, the destruction of Libya's infrastructure then gave rise to the circumstances for two new governance arrangements established for Libya at the international level. The first, to manage counterterrorism, that is to ensure that any threats that may emanate from the lawlessness that now prevailed in Libya following the destruction of the country's infrastructure and the overthrow of its government would be contained within Libyan territory. And second, a migration governance regime to ensure that Africans could not use Libya as a transit site to access the Mediterranean Sea or Europe. So I'm going to turn in the remaining minutes of my presentation this morning to the counterterrorism frame. And here, at the end of intervention in Libya, left in control of the country, the militias with which, that had been framed as rebels, the militias with which NATO had partnered during the course of the UN Security Council authorized intervention. In the east of the country, these militias had complete control. In the west of the country, an internationally supported interim governance arrangement was being attempted to be stood up. The rebels that had been portrayed as freedom fighters during the intervention, however, quickly came to be reframed as extremist jihadis. And these militias, or that were understood as terrorist actors now from the perspective of the West, had, of course, free access to the arms that had flowed into the country under cover of Security Council authorization during the intervention. So during the intervention, they were armed to a dramatic extent, and the country became awash in weapons and indeed became a transit hub for the flow of arms into other parts of Africa, notably Central African Republic and Equatorial Guinea. But following the intervention, the fact that you now had these armed actors on the ground was reframed as a significant threat of terrorism to the international system. And this was especially pronounced after the attack in Benghazi on the U.S. diplomatic compound, which resulted in 3 U.S. deaths, but which paved the way for a new counterterrorism governance regime in the region that would be responsible for hundreds of Libyan deaths. So these rebels, portrayed once as freedom fighters, became terrorists, and counterterrorism framings, in turn, produced a version of Libya that became a laboratory for refining doctrines that would support the use of drone strikes, the application of targeted abductions, and extrajudicial killing on the territory of Libya without need for sovereign consent by Libya. So just to remember, the humanitarian intervention, of course, put aside Libyan sovereignty in the name of humanitarianism and protection of the civilian population. Their Libyan sovereignty was penetrated for the first time, rendered contingent on humanitarian grounds. Now Libyan sovereignty and consent is once again put aside in the name of the overriding importance of counterterrorism governance for the international system. So if Libyan authorities, such as they are unwilling to consent to the use of targeted abduction or killing on Libyan soil, that is not going to prevent the deployment and development of new doctrines justifying such actions in the names of securing the international system against threats that might emanate from Libyan soil. At this time, external backers had come to support different factions on the territory of Libya itself. So in the east, you had the development of the self-proclaimed Libyan National Army with enormous amounts of funding and support, not only from the Gulf Arab states, but also from France and other Western actors. Eventually, under the Trump administration, even the United States lent support to this Libyan National Army. On the other side, you had a UN-backed interim arrangement in the western part of the country called the Government of National Accord that was also internationally funded and supported, also by the United States for a long period and by other actors in Europe. So you had two different factions, both being armed and both being supported by external actors, and turning the country into something like a free fire zone as different powers wrestled and jockeyed to gain control of the whole of Libyan territory at the expense of the civilian population. Against this background, you could first of all argue that neither of these entities, the Libyan National Army or the Government of National Accord, represented the full sovereign authority over the entirety of the territory of Libya. And this framing that there is no clear sovereign, there is no clear official to whom to address demands for consent for use of force on the territory of Libya, proved, of course, extremely convenient. This becomes a license for international intervention at will, ad hoc interventions defined by the security prerogatives and needs of Western actors, as opposed to in partnership with any authorities that may be on the ground in Libya, or, of course, in the interest of the Libyan population. In fact, the Libyan population was being victimized at the hands of the militias that had been empowered by the intervention and now were being framed as terrorist actors. So much like the original intervention, counterterrorism policies in the country set aside Libyan sovereignty in order to enable drone strikes. So when objections were raised by Libyan officials themselves that these strikes had not been the subject of consent and that the kinds of damage that was being done in parts of the east of the country as a consequence of drone strikes was unacceptable, the response was to evolve new doctrines, including the idea of confidential or secret consent having been provided for these kinds of aerial interventions, drone strikes, and other forms of targeted intervention by actors not named that were being deemed relevant officials for Libyan purposes and sufficient grounds for intervening parties to set aside the prohibition on the use of force in the UN system in favor of using force as needed to address terrorist threats. This, of course, is important not only for Libya. This is the development of new international law doctrines that are permissive of the use of force more generally. Once you develop a doctrine of confidential or secret consent being provided by some authority on a territory when it's not clear which authority necessarily governs, that's a prescription that can be used in any number of other theaters of conflict. So Libya becomes not only a zone that becomes something like a free fire zone, as I described, for counterterrorism purposes on Libyan soil, but a laboratory for the development of new doctrines that themselves can compromise further the sovereignty of the countries of the global south more generally. An additional governance regime then deployed against Libya further illustrates the logic of the relationship between external interveners and the militias now framed as terrorists that were armed and empowered on the ground in Libyan territory. And this is in the migration context, where these same militias, the militias that are the object of the counterterrorism governance framework, are restyled as partners for Europe in the containment of Black migrants from departing Libyan soil. So once again, and contemporaneously on the same territory with respect to the same actors, on the one hand, they represent threat, requiring a management regime involving the use of force on Libyan territory without consent, or with these liminal forms of consent that introduce new international law doctrines that are permissive of external use of force on Libyan soil. And on the other hand, the very same actors are stood up as part of the Libyan Coast Guard, an entity created by the European Union, funded by the European Union, in order to ensure that actors on Libyan soil police the Libyan shoreline to prevent anyone from accessing the Mediterranean Sea and crossing it into Europe. So in this period, the Mediterranean Sea itself becomes a highly militarized location, but the way in which migrants specifically are targeted and framed and these militias are empowered to detain them is entirely racialized. So again, just as we saw in the mercenary context, Black Africans are portrayed as non-Libyan, as foreign, and as suspect on Libyan soil to be rounded up and detained and held in detention centers or migration camps in a variety of conditions under European tutelage in order to mark who constitutes a migrant, who constitutes an outsider to Libyan soil, and who is to be prevented from accessing the Mediterranean and transit to Europe. This framing has enabled an enormous array of new practices on Libyan territory that were unseen prior to the 2011 intervention. Most notably and most outrageously, many of you may be aware that there was a discovery of slave markets being operated out of migration detention facilities in Libya, again, marking Black migrants as clearly racialized subjects, or in the words of my co-author, the racial border of Europe themselves, carrying the border on their bodies and then having their race further mark them for commodification in the midst of the kind of empowerment of armed actors on Libyan territory, and also the concentration of individuals in detention facilities and camps that themselves become death traps, including most notably in the story that we narrate in the paper of the strike on the Tajura detention facility. So strikes by rival Libyan forces against one another, with these migrants trapped in containment areas in the middle, in the crossfire, being killed by the scores, women and children, as part of a governance and containment population management regime being enforced by Europe as part of a broader scheme to prevent migration to Europe. So again, whether in the context of the humanitarian intervention that sets aside Libyan sovereignty, or in the context of the counterterrorism and migration governance regimes that we narrate, the relevant interest, the security goals, the regional ordering, all of the things that are in the service that international law serves are related to the security interest and general understanding of what is required to preserve European, Western, regional arrangements and interests at the expense largely of the Libyan civilian population. So what we tried to do in our analysis is demonstrate the ways in which these logics operate both through what we describe as the ongoing imperial ordering of the international legal system, but also through a very specific racialized logic, deploying Libyan Arab identity in particular moments as it's convenient, remarking individuals who may be Libyan themselves as foreign or Black at other moments when convenient, and using the overall placement of Libya as an Arab and African state to the sort of deploying it as expeditiously as possible to serve these broader international interests at the expense of the Libyans that were at first styled as the civilian population in need of rescue and for whom the Western interveners were to be understood as humanitarian responders. So that's the original framing, the international law story about what happened in Libya that we wanted to unsettle and to demonstrate using a TWAIL and CRS lens what the same picture might look like if you focus on both the imperial dynamics at play and the racialized logics at work in international legal governance.
We hope you enjoyed today's episode of the Race and Rights podcast. This podcast is hosted by the Center for Security, Race and Rights, housed at Rutgers Law School, also known as the People's Electric Law School. CSRR engages in research, education, and advocacy on issues that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. We do so through an interfaith, cross-racial, and interdisciplinary approach. To hear additional episodes of the Race and Rights podcast, check out our pages on Spotify, Apple Podcasts, Amazon Music, and everywhere else podcasts are available. Now, for a deep dive on these issues, visit our website at csrr.rutgers.edu, where you can find policy reports, teach-ins, and news commentary by our over 130 faculty affiliates. To watch our over 80 academic and public policy lectures, subscribe to our YouTube channel at Rutgers Center for Security, Race and Rights. And on social media, be sure to follow us on Instagram at Rutgers CSRR and on Twitter and Facebook at RUCSRR. Finally, you can financially support the Center for Security, Race and Rights by going to our website at csrr.rutgers.edu and press the donate button. And please give generously. As always, be well and see you next time.